absent objection, Mr. Valiant, could you tell us your position at this point about what you think the status of the remedies is, the judgment, the future remedies? If that's not clear, let me try again, but do you know what I'm asking you?
Yes.
Okay.
They're trying to treat the merit council like a court, and by the way they filed these different pleadings in the way they're headed. I mean, the merit rules, I think, speak for themselves, and I think that they say that court rules, and the rules of evidence and that type of thing don't apply to this. I mean, this is an administrative body, is it not? I said, this is an administrative body, and I think they're trying to treat it like a court. And I just think there's a difference in the way that those are treated. Now, this body heard this evidence for a day and a half. Ms. Dooley is resigned. I'm not sure if there could be a remedy, especially what they're asking for here. I mean, they're wanting to reconsider what a hearing that we've had for a day and a half. Everything they've alleged in their pleadings has already been considered once. I guess that's, did that answer your question?
Mr. Wright, do you have anything to ask of Mr. Valiant? Ms. Oster, Mr. Marshall?
What are your intentions going forward on the Department of Business behalf?
Well, she resigned.
Okay. Okay. So that's it then?
The only, and I haven't looked into this, the council awarded attorney's fees, and we haven't even discussed that. So I don't know whether her resigning cut off, all rights to the future of my seeking attorney's fees, or whether it did not. Right now, she's quit. And that's it.
Any other questions from Mr. Valiant? Would you like to jump in and limit yourself to that one question, or that bifurcated question? I'm not asking you for a statement or to argue your motion, but just the same question that I asked Mr. Valiant.
In an effort to comply with your request, I brought the learned name guest to answer that very question, which we have gone over. Go ahead, Dan.
All right.
Well, Your Honor, when you left, you said that you were going to take this chance to meet with the members of the board to discuss the process, and I assume you were talking about my process of filing a request for reconsideration.
Yes.
Okay, and if we look at, I'm assuming that this Merit System Council was developed under the Administrative Act of 1974, and I know there's some commission meetings on that, but
Go ahead, I'm sorry.
but go ahead. But anyway, if you look at TCA 279114, it says that civil service employee municipal boards are to be conducted in conformity in contested cases with the Uniform Administrative Procedures Act. And that's set out in 45300-01 at SEEK. And so what we've done is file that petition for reconsideration pursuant to 4-5-114. And so that's how we got where we are right now on that petition for reconsideration. It's by statute, it's just by state law. And that's what we're going under, and we've cited all this in the petition, Your Honor, and I've got copies of the statutes if you want to take a look at it. Now, that answers I think that answers the first part of your question about why we're here. Now, the second part, can you tell me again, what's the second part of your question?
Well, not really. These policies and procedures.
Yes.
Do they deal directly or indirectly with a particular petition to rehear.
There is not a, quote, petition to rehear rule.
Or anything like that.
No, it's set out by state law.
That wasn't my question.
Okay, and I think I answered that. I don't know of anything in the Merit System Council rules that deals with a petition for rehearing.
Okay.
Or reconsideration.
Excuse me, for reconsideration, if that's your direct question. I'm not
Yes.
aware of it in the Merit System Council rule. It's under the statute.
Oh. So what, I'm not arguing with you, just asking a question for information. What, if anything, gives you the right to file it with this body, under these policies and procedures?
Again, I go under the statute. Under that, the Merit System Council rules do not set out anything with regard to an award of attorney's fees. That's not in there either.
You can argue that.
And that's one of the.
fine. I didn't say they did.
Okay.
So, that's not an argument.
All right. I wanna make sure I'm answering your question. I am not aware of anything specifically in the Merit System Council rules, outside of what I've talked about state law, that says there is a motion for reconsideration under the specific rules that are sitting on the desk in front of you.
Where does the administrative law tell you you can take a motion to reconsider or to rehear?
45114, Your Honor.
Where,
Tennessee TCA.
what court or body does it tell you you can take that and file that proceeding in?
It says that I am to come back to you, Your Honor, or the board, this board.
It says a board.
Yes,
Okay,
to do that.
okay,
And that's what I cited in the petition for reconsideration.
okay. And what are the remedies provided by that statute?
Well, then this board would then either say, we're going to rehear it and reconsider it, and here's our ruling, and here's the law, the facts, and all the things that we've addressed in here, and here's your time frame for filing an appeal, etc. Or the board could say, we're not doing anything, and then our remedy is then a judicial remedy to Chancery Court. And that's all set out in the
Okay, and
code
those,
that I've.
thank you, I appreciate that.
Okay.
So those are the only two remedies under that. Either grant the motion to rehear or deny the motion to rehear.
Correct. If they're still pursuing this attorney's fee issue, I think that is the only option available.
Why would that make a difference?
Because nowhere is there any right, nowhere is there any right to attorney's fees unless it's by statute, section 1983, civil rights,
Oh.
and the Constitution of the United States, the American system versus the English system. Go ahead now.
Okay, yeah, I'm kind of aware of that after
I
25 years.
know, but you asked me why, they come up with attorney's fees, and she didn't even ask for attorney's fees.
I
They came
understand,
up for
I
it.
understand all
All right,
those
I'm sorry,
arguments.
go ahead, Dan.
But is that the only reason that you would give that answer?
It is, Your Honor,
Okay.
because the attorney's fees issue is what causes this to be an appealable issue at this point, because it's my understanding she's retired, Ms. Dooley has retired, so the car and the gas card issue are now nullified, I would assume. Mr. Valiant, is that
Okay, well.
your understanding or not?
Is that a?
If not, then we'll have to appeal that too.
Okay,
so
well,
I
that's
don't-
that's what we're trying to get to.
Yes.
Are you still, Mr. Valiant, pursuing, and if you need to think about it or whatever, fine, but are you still pursuing the car and the gas card? If you are, fine, I'm just asking.
No, we're not pursuing the car and the gas card.
Okay, is that, you want more time to discuss that, or is it?
No, that's,
Okay.
we're not gonna pursue the
All right.
car and the gas.
So the only issue then is the attorney fees, is that correct?
Correct.
Okay. So,
that leaves us where we are, Your Honor, but
yeah.
if you got any other questions, I'd be glad to
No,
answer.
I appreciate that, and you were doing fine, I'm just getting old, I can't remember.
I can't say anything about getting older, Your Honor.
You're a youngster.
Yeah,
Forget it.
right. Okay. So, does that call the need to discuss this further in executive session, or are we ready to go ahead?
Your Honor,
You're the ones making the decisions. I mean, at this point, I know you're gonna make an argument.
No, if you need any of this review, I've got them here.
I've
if you
got
wanna
it
take a
all
look at
laid out for you.
Okay, they're the ones gonna be making the decision, not me. You need to talk about it any further, or are you ready to proceed?
I do have one question to Mr. Prince or Mr. Gass, is that,
It is, yeah.
I'm sorry, this is Dan Gass, my wonderful partner with O'Neill, Parker, and Williamson. We practiced law for many, many years together, and he is my right hand. And I'm his left hand or something.
okay. My point is, if Miss Dooley is no longer employed by the sheriff's office, the car and the gas card would be moved, right? She's not asking for that. Is there another particular reason that we're having to spend taxpayer money to continue to do this in court? Because this to me seems frivolous and wasteful at best.
Can I start and let him come back clean up?
Whoever wants to answer my question.
Both of us. Number one, we have a ruling by the old merit board that you all awarded as a group attorney's fees. Now, we have now a ruling from a tribunal that says, no matter what she does or doesn't do, you all have ruled that the merit board has the authority, and we did it, we awarded attorney's fees. And it's our position that she didn't ask for attorney's fees, that's something that you all came up with. That was arbitrary and capricious. Number two, nowhere in any statute does it allow the prevailing party, Mr. Bang says he prevailed, I take issue with that, of course, and nowhere in the American system do you allow the prevailing party to get attorney's fees. That's only in England, or like the work we all normally do is civil rights, Section 1983, protecting those wonderful officers who serve and protect. And if we get beat, the other side gets their attorney's fees because the other side, they want to promote people to go to attorneys that have alleged their civil rights violated. That's not happened here. For some reason, the old merit board said we award attorney's fees, so therefore we must proceed either here or upstairs or somewhere and say, no, merit board, old merit board, you can't do it. New merit board, we welcome the new merit board. Dan, anything else?
No, I would just like to add, I agree that we do not, I'm not aware, and this board can correct me, but I'm not aware of anything that allows for an awardance of attorney's fees. There's no contractual issue here, no written contract that would allow for attorney's fees, et cetera. And I'll go back to some of the law that I was citing to Her Honor a minute ago. If we look at TCA 4-5-314 under the Administrative Procedures Act, in the final ruling or order, whatever the decision of this board is, you're to include your conclusions of law, the policy, reasons thereof, the finding of fact, and the remedy prescribed. And I don't recall the board ever citing to a specific law or policy reason thereof that was, say, set out in the merit board rules. And that's one of the reasons why the request for reconsideration.
So if we had not said anything about attorney fees, then you all would have dropped this now that Ms. Dooley's gone, and you would have been done with Judge Haggerty. No, so we're still gonna continue to spend the money.
No, I don't know. I can, it's like someone calling you up for legal advice. I can only address the issues as they come up.
I understand, Mr.
I can't
Prince.
say what I'm gonna do in the future, not gonna do in the future.
I understand,
All that, I'd
but-
like to cut off the attorney's fees for the sake, I'm arguing, for the sake of Knox County, for the sake of the public, for the sake of the sheriff's office, for everybody. As I told this board day one, guys, look at the law, listen to Myers, listen to the book, listen and apply the law. That's all I'm asking.
So this answer, but that answers my question. So if attorney fees weren't included in the decision, Ms. Dooley's gone, you'd have pulled that out of Haggerty and we wouldn't be continuing to spend money.
No, I
Because
didn't-
what is the point at that point? It's moot now,
No,
she's not there anymore.
I didn't know till you all, just
Okay,
ask
but
him
now
a
you
question.
know, so
Now you
what
know.
is your answer?
You should be able to answer that.
What's the question?
If
You
we
said
had-
if,
If
you're
we
asking
had
me
not
now?
given, if we
Yes.
had not given attorney fees.
Yeah.
You would have pulled the case from Judge Haggerty's court, and we would be done with this lawsuit and quit spending the taxpayer money.
I'm not in Judge Haggerty's court. Listen to me, I'm
With
not
this?
involved in that one. No, Cole.
You'll be courteous and civil
Okay,
in this proceeding.
yes, ma'am.
I have been treated poorly at best by you, Mr.
Oh,
Prince.
you have been treated very nicely.
No, you have, I have not.
Okay.
So when I ask a
Let's
We
put
are
the
question,
not,
wham whams away.
we are
Quit
not,
wham-wham.
Mr. Gass, do you have any control? We are not gonna go through
Can I
a
say-
back and forth.
Can I say something, Your Honor?
I have never said anything in this
All right.
derogatory.
Now,
You said, you just took offense. So
all
what?
right,
Ms. Sister, I think if I understand counsel correctly, that they are basically withdrawing the claim for the car and the gas card because she's now retired. If that's correct, and this board overrules its previous ruling as to attorney's fees, then I do not see anything to appeal at that point, because that's moot, that's gone. And if you won't override your previous ruling with regard to attorney's fees, then I think that's gone. Now, you mentioned something about the Chancery Court. I don't think that action is currently pending.
Yes, sir.
This, by statute, would have to be an appeal, a separate issue, to Chancery Court, if the attorney's fees stand. Does that answer your question? I wanna try to answer it for you.
No, I appreciate it. Can I ask Mr. Valiant a question?
it's gonna be the same question I'm gonna ask you.
What is your opinion on the attorney fees?
Now, can I back up just a little bit? I don't agree with them at all, that when they passed the 1974 Act, in order for it to be effective, the county commission had to approve it by a 2/3 majority. It went before the county commission back then, and they did not approve it. So if everybody will recall, this issue came up again before county commission just recently, and the sheriff's office was trying to get the county commission to do away with the merit council under the charter, and say that we'll go back to the act of 1974. In order to do that, the county commission would have had to approve that by a 2/3 majority, and that's what they most recently have said. So the act of 74 does not apply. This act comes under the Knox County Charter, which created this body. And I think it was a charter of 1990 created the Merit Council. And the rules that you have in front of you are what governs this body. Now, I may have dreamed it, imagined it, but I believe, first of all, attorney's fees, and the chancellor knows better than anybody in this room, attorney's fees can be awarded by contract or by statute, or I guess by these ordinances. And I believe that in the ordinance itself, there is a reference to attorney fees can be awarded. Now,
Which
Where?
ordinance, which ordinance is
Where?
that?
the merit council rules.
Where? Where?
Mr.
not-
Gass has the floor
All right,
until
all right,
he
I'm sorry.
relinquishes it.
I will hush.
I am not aware of that, Your Honor. If Mr. Valiant can tell me what that is,
Do you happen to have any?
I'm not aware of it.
If I had have really, I thought we were just here on it, not on whether or not they were entitled to a motion to reconsider. But as I recall, it was somewhere toward the end of those rules. Now, if it's not, we won't pursue it. If it's not in that rules and procedures, covering the merit council, I can assure you, this will go no further.
Is there a way that we can immediately find that out right now?
Myers?
Can we ask our executive director? that's the
Our
professional
executive,
on
Yeah.
do you know, Mr.?
I'm not aware of it, but I do not have a copy of the manual with me.
Would you have them in your office? May she get the copies in her office?
Your Honor, are you talking about the Merit System Council rules?
Yes.
I've got a
Oh,
copy.
the merit system,
Got them in front of me.
policies and procedures?
Yeah.
You're not talking about that, are you?
Yeah.
Oh, that's not that.
I thought that's what he was speaking of.
No, you're talking, you're not talking about these, are you? Or
Yes.
are you?
Yes. If they're not in there, they're not.
Mr. Gass has not, Mr. Prince, we're gonna try out whether a hearing officer has the authority to issue civil contempt. We're fixing to find that out. Now, I may be
Let's do it.
wrong, but we're
Let's do
gonna
it.
find out.
Let's do it.
Yes, sir.
Let's do it.
I haven't memorized them, but
Everybody may be right, and I wish.
There's that one section in there.
yeah, I'm gonna find that for him. Look up, it starts it out.
I was thinking that it was, you got these things all tabbed up.
Now, if you look at 9.4.2 C,
9.4 C.
.2 C, page 24. All parties to the hearing have a right to appear before the council in person and to retain counsel at their own cost.
Right.
Now, that may not be fully determinative, but if you look at the remedies, 9.4.2I, if the council finds the sheriff has not complied with procedures or occurred for political reasons or arbitrary in the interpretation, the council may order the employee to be reinstated with back pay. That's the only place that I'm aware of. Mr. Morton, do you know of any other remedy contained within the policies or procedures?
No, I do not believe that the
Ms.
council
Taylor,
can award attorney fees.
now you don't have to accept our rendition of the law, obviously.
Your Honor.
You wanna recess, would that help any or not?
How about 10 minutes? Would that be too long?
How about what?
10 minutes.
Sure.